All rise. The Court of Appeal in the 5th District of the State of Florida is now in session. The Honorable James A. Edwards, Chief Judge, presiding. All persons having business before the court draw near, give attention and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Well, good morning and welcome to our holiday session of oral arguments. What a festive one we have for this morning. I was already introduced. I'm Judge Edwards. To my right is Judge Soud, and to my left is Judge Kilbane. We have one case, and that is Optimum RX, a successor by merger to Catamaran Corporation, and Optimum RX in its own right versus Bayy Pharmacy et al. Each side will have 20 minutes. Typically, what we reserve is 5 minutes rebuttal for the appellant. If you want something different, just tell us. The way our system is set up with the little lights, green means you've got all your time, yellow means you're into your rebuttal time, and red means stop. I'll try to keep an eye on the rebuttal time. If you get way into it, I'll probably let you know. It's your time. You can do anything you want with it. So when you get see the yellow light, you can politely end your questioning, answering, as bad as Biden. End your answer or wrap it up, and we'll go from there. So with that, counsel for appellant.
Thank you, Your Honor. May it please the court, Michael Holacek for Optum RX. I would like to reserve 5 minutes for rebuttal, please. The circuit court denied our motion to compel arbitration because the parties' contracts call for arbitration in California. This court should reverse. Under both Florida and federal law, a Florida court must enforce valid arbitration agreements, no matter where the arbitration is supposed to take place. Also, Bayy Pharmacy is wrong that we don't have a live dispute between the parties here. Under the law, all that's required is us showing that there is an arbitration agreement and alleging a refusal to comply with that agreement. Bayy admitted in its answer that it refused to arbitrate under our contract. That's in the record at A1263. I'd like to start with the Florida Arbitration Code. The text of section 682.03 is clear. It says that if a person shows, I quote, an agreement to arbitrate and alleges another person's refusal to arbitrate, then the court shall order the parties to arbitrate. There are no exceptions in that statute. Now, before 2013, there was an exception. If the parties stipulated that Florida law doesn't apply to their arbitration agreement, then the arbitration code didn't either. But the legislature repealed that provision in 2013, and legislative repeals mean something. When we look at the arbitration code today, there's no provision that allows a Florida court not to enforce an arbitration agreement just because the arbitration is supposed to take someplace else. Now, there are 21 other states that have the same uniform arbitration code as Florida, and there's never been a court in any of those 21 states that has ever held that they lack the authority to compel arbitration because arbitration is supposed to take place somewhere else. Just a couple years ago, the Nevada Supreme Court, in the DCA case at page 18 of our brief, confronted this same issue. There was a contract that said California law applied to the arbitration agreement, and the arbitration should take place in California. And the party there made the exact same argument that Bayy Pharmacy makes here. Because the arbitration takes place in California, you, a Nevada court, can't compel arbitration. And the Nevada Supreme Court rejected that.
Let me ask you a very basic question, and perhaps I'm oversimplifying, but in December of 2021, Bayy Pharmacy et al. Writes a dispute letter and basically calls it that, so kind of works to your advantage there as to whether there's a dispute or not, because they call it a dispute letter. But they basically say in 8 different ways, Optum, you're doing my guys wrong. Do you want to work it out? Period, have a nice day. There wasn't an or else, there wasn't we're going to stop filling prescriptions, we're going to go somewhere else, there wasn't anything. It's just like, we're not happy with what's going on now, let's try to work it out. There was apparently at least a phone call of some type referenced in the record, and that didn't work in a resolution. And my question for you is, if their letter says, we're not happy, period, we think you've done these things to us, period, but we're not doing anything about it, what are you going to arbitrate? You're going to make them do something about it?
Your Honor, they specifically refer to breaches of both the provider manual and state law and refer to them as claims. And I'd like to put it into context where this letter came from. If you look at the arbitration agreement, it's basically a three-step process for resolving disputes. Step one, you have a dispute, you send a notification of dispute letter. That's what they titled their letter. Step two, you have a phone call to try to resolve it. Step three, if you can't resolve it, you arbitrate. There's no dispute here, we did the first two steps. They sent the letter, we had the phone call. At the end of the phone call, I said, next step is arbitrate, will you arbitrate? They said, no, not under your contract, we won't arbitrate. So in the context of that, we followed the first two steps of the procedure, and this is the dispute resolution process we bargained for, that we paid them almost $3 million of, under 1 year alone. And now we're at the third step. It's our position we have to arbitrate this. Their position is we don't. And we continue to pay them every single month. That was undisputed.
Counsel, can we talk about the arbitration provision? You reference repeatedly throughout your papers that you're traveling under the 2022 agreement. Is that correct?
That is correct, Your Honor.
All right. How does that apply to a letter that was sent in December of 2021? I understand that had that been in existence, I understand the language in the 2022 provider manual, but that was not in existence at that time. I know at least at this point, at least one other court has said that is not how this should be read. So how are you traveling under that agreement here?
Your Honor, so we put in the record every year's provider manual. There are no changes in the arbitration agreement between what was in existence December 2021 and 2022. Bayy Pharmacy never raised this argument that you really should be looking at the 2021 instead of 2022. If they did, one sentence, here are the cites to the two provider manuals. There is no change in the arbitration agreement for those two.
Was there a choice of law change?
No, there was not. The choice of law change happened in
2020?
2020, Your Honor.
Okay.
Yeah.
Thank you.
Of course, Your Honor. And so we have the refusal to arbitrate. It's on a phone call. Bayy Pharmacy's argument is that you need something more. It needs to be documented in a letter. It needs to be multiple times a refusal to arbitrate. But that's not what the statute says. They're trying to add something beyond the text, some requirement. The statute itself just says an allegation that the other side refused to arbitrate. Here, I submit we have more than an allegation. We allege that in our petition. They framed it as a denial of that, but their last sentence of the denial said, yes, we did say we're not going to arbitrate under your unconscionable arbitration agreement. So we not only have the allegation, but we have it really undisputed. And that's all that is required under the statute. I would like to talk about the interplay between the FAA and the Florida Arbitration Code as well. There have been 7 district courts of appeal that have looked at this issue of what do we do when an arbitration agreement is governed by the FAA, and the other side raises this, what I'll call the Deora argument, the argument from the Florida Supreme Court that a Florida court can't compel arbitration in another state. And all 7 times, in all 7 of those cases, and we cite them in our brief, that's the Mintz case, Coastal Health, Trojan Horse, every time the court said if a contract is governed by the FAA, we can't apply this Florida rule that says that we're not going to enforce your arbitration agreements because the arbitration is going to take place somewhere else. That would conflict with the FAA, and if there's a conflict between the FAA and the Florida Arbitration Code, then the FAA trumps that. And I think the best of those 7 cases, which is just the most clear on this point, is the Trojan Horse case, and that's on page 18 of our reply. And it basically says that to the extent there was some loophole before 2013 that courts didn't have to apply, didn't have to enforce arbitration agreements if the arbitration was supposed to take place somewhere else, that's inconsistent with the FAA. Florida courts can't apply that rule when the FAA governs a contract, and so the court must enforce that arbitration agreement. And like I said, there are 7 decisions, appellate decisions, that affirm that point. There have been none of them going the other way. And we respectfully submit that this court shouldn't be the first to create that split of going the other way.
What about, oh, sorry, go ahead.
The trial court didn't rule at all on the FAA.
They didn't. At a minimum, there should be some type of remand for the trial court to consider that in the first instance.
Did you move for rehearing or reconsideration on that point?
No, Your Honor, we didn't, nor do we think that there was any requirement to do so. We raised the argument both in our briefs and in the transcript, which is in the record. And under the Pensacola Beach versus King case, that's 66 Southern 3rd 321 from the first DCA, a party is prohibited from filing a motion for reconsideration or rehearing simply to re-argue what has been argued below. That court holds that a motion for rehearing or reconsideration is appropriate when there's a new factual finding that was made or was required and the court didn't make one. But where there's a new, where there's an issue of law that was argued by one of the parties extensively in the briefs and at oral argument, that case holds that there's not only do you not have to do it, but it's prohibited in those types of circumstances. There's been that's not an argument that Bayy Pharmacy has made here, that we were required to file a motion for reconsideration, and we don't think that would be appropriate here. I would like to briefly mention the Deora case because Bayy Pharmacy has raised it so many times. Their argument is that the Deora case didn't specifically mention this statute that was repealed in 2013, and we disagree with that. I looked at the Deora case again yesterday, and it's a short opinion, but halfway through the opinion there is the sentence that starts with "we hold." So this is the holding from the court, and it's one sentence. It says, "We hold the provision that arbitration was to take place in New York constituted a stipulation that the Florida Arbitration Code should not apply. See section 682.02. The Florida courts have no statutory authority under Chapter 682 to compel arbitration in another jurisdiction." So you have the Florida Supreme Court basically mirroring the language of 682.02, saying that there is this stipulation not to apply Florida law, citing the statute, and saying that is the holding, the basis for its ruling. And that is the exact provision that in 2013 was repealed. And like I said, every court outside of Florida that has the exact same uniform revised arbitration code has come to the same conclusion, that there is jurisdiction to compel arbitration in another state. The last thing I'll point to is back to that DeSage case, because it's recent, from the Nevada Supreme Court. What it comes down to is that court looked at the jurisdiction statute in its arbitration code. Exact same jurisdiction statute here. Here it's Florida Statute 682.181, and it says, "A court in this state having jurisdiction over the controversy and the parties may enforce an agreement to arbitrate." That's the provision here. It's also the provision in Nevada, and here there's plainly jurisdiction over this controversy over the parties. Circuit court is a court of general jurisdiction. We pleaded an amount in controversy above, at the time, $30,000 was the threshold. Bayy Pharmacy doesn't dispute that there's jurisdiction over it. It does business in the county. And so there's general jurisdiction over the controversy in the parties. And looking at that same code provision, the Nevada Supreme Court recently said, you can compel arbitration in another state.
Going back to the FAA real quickly, your opponent seems to think that the FAA only authorizes United States district courts to employ that law. What's your view on that?
Your Honor, so in federal court, if we were in federal court, there is currently a circuit split about what that provision means and whether you really can only file your petition in that district court where the arbitration is to take place. Some federal courts say, yeah, it means exactly what it says. You can only file it in that district court. Others have concluded otherwise. But we're not in federal court here. And so that provision that you should file it in the district court where the arbitration takes place simply doesn't apply. The next sentence says that the federal rules of civil procedure apply to that petition. The courts have repeatedly said that doesn't apply in state court either. We're not going to displace your rules of civil procedure, if you're in state court. And so that provision is simply inapplicable. The U.S. Supreme Court, including in the Taflin case, which was a RICO case, said when Congress uses words like file something in a U.S. district court, that doesn't supplant the concurrent jurisdiction of the state courts. If it did, that would mean RICO wouldn't apply in state courts. And there's never been a case that says that references to a U.S. district court means that somehow strips state courts of jurisdiction.
But counsel, doesn't that mean generally that you can have arbitrations in state court and federal court? It doesn't necessarily mean that a state court on its own could move under this Section 4, correct? I mean, you would have us ignore the first couple of lines of this.
Well, the first line basically provides a substantive right that if you have an arbitration agreement and the other side has refused to comply with it, language almost identical to the Florida Arbitration Code, you can get an order from a federal court compelling the parties to arbitrate. And that's the substantive right that applies both in state and federal court. The provision about which U.S. district court to file in, that we submit is just inapplicable here because we're not in a U.S. district court, and the U.S. Supreme Court has made clear that those types of references to U.S. district court don't limit the state court's concurrent jurisdiction. If there are no further questions, I'd like to save the remaining of my time for rebuttal, please. Thank you, Your Honor.
May it please the Court, Mark Cooker for Bayy Pharmacy of Eustis, Florida. If you don't mind, I'd like to just pick up with the Section 4, since we're talking about it anyway. It's not me who seems to think it says a federal court, it's the statute, and it says it in 3 places. It says an aggrieved party may file, upon refusal to arbitrate, may file a petition in any United States district court which, save for such agreement, would have jurisdiction under Title 28. In other words, this does not create federal jurisdiction. You need an independent basis for federal jurisdiction, either under diversity or federal question or something else. Then it goes on to say, the hearing and proceedings under such agreement shall be within the district in which the petition for an order directing such arbitration is filed. This has been almost universally interpreted to mean not only do you have to file in a federal district court, it has to be in the district where the hearing will take place. Now, Optimum is fully aware of that. The same day it filed petitions in 8 Florida counties against my clients, it filed 250 petitions to compel arbitration in the federal court for the Central District of California. So obviously they're aware of that. Why they decided to burden the Florida courts with this litigation, I don't know. But they obviously knew that. Now let me talk about the so-called circuit split. The so-called circuit split is a Fifth Circuit case called Depew Bushing General Agency versus Ambassador. They cite it, I think, in their reply brief, 524 F. 2nd, 1275. But let's look at what happened in that case. Somebody filed a breach of contract action in Mississippi State Court. You've read the case? I'm very impressed. I'm really impressed. And it was removed to federal court. And when it removed to federal court, the defendant moved to compel arbitration in New Jersey. For some reason, the court focused on, this is clearly a Section 3 of the FAA case, but they focused on Section 4, and they said was, Because the party seeking to compel arbitration did not invoke the jurisdiction of the Mississippi court, but only responded to the actions of the plaintiffs, it was appropriate for that court, that federal court sitting in Mississippi, to compel arbitration in New Jersey. So when a plaintiff the message of that case is, when the plaintiff initiates a lawsuit in a district other than the district where arbitration is to take place, the party seeking arbitration may assert its Section 4 right to have the arbitration agreement performed in another state. If we filed suit against Optimum in Florida, there's no question they could move to compel arbitration, really under Section 3, not Section 4. But there's no question they could do that. Let me go to the issue of the so-called bargain, what they bargained for. That's frankly a joke. My client never signed an agreement containing an arbitration clause. The way these things work is they post a provider manual online. There's an arbitration agreement on page 125 or 130, and as soon as the pharmacy submits a prescription to be paid by insurance, they're deemed to have agreed to arbitration. Okay. It is worth looking at the A&S drug case, which we submitted as supplemental authority. It's worth looking at for at least two reasons. First, the court applied California law. And secondly, the court strictly construed any ambiguity, any uncertainty in that agreement against the drafter. I mean, and candidly, if there's anything they don't like in the agreement, they could just change it. They've already changed it a couple of times. They take the position any change it makes, they make is effective retroactively. We have a big issue with that, but that issue is not before this court, I don't think. But, you know, clearly we think that they had no right in 2020 to retroactively nullify a decision that said pharmacies had a right to have unconscionability determined by a court. But that's just an aside. So let's look at what this contract let's look at the Deora case first, okay? I certainly acknowledge the statute has been changed, but let's look at the full context of what the Supreme Court said in Deora. First, they said the Florida courts have no statutory authority under Chapter 680 to compel arbitration in another jurisdiction. Then they went on to say, further, the agreement between the parties failed to specify that either Florida law shall govern or that Florida arbitration procedure shall apply. The inference from the wording of the agreement is that New York arbitration law shall govern and American Institute of Architects procedure shall apply. And then the court said the most critical thing for this whole case: the rights of the parties under this arbitration provision stand or fall upon the contract terms, not the statutory arbitration procedure in this state. What does this contract say? It says the Federal Arbitration Act governs both the substantive and procedural aspects of this arbitration. It doesn't say we reserve all rights under your state arbitration clause. It specifically excludes any other state law except for California, because the provider agreement, which they always ignore, says on page 871 of the record, section 11.11, this agreement and the rights and obligations of the parties hereunder shall be governed by and construed in accordance with the laws of California without giving effect to the conflict of law principles thereof. So under this agreement, where they drafted, they have remedies under federal law, but that section 4 doesn't give them the right to bring a case in state court. They have remedies under California law, but they essentially contracted themselves out of any other state law. Remember, any ambiguity should be construed against them. Now, one case I think is very instructive is the Volt Information Sciences case, a U.S. Supreme Court case, which is analogous. The differences will be obvious, but it's analogous as follows. In that case, there was a California choice of law clause. California has a statute that says you can enjoin an arbitration proceeding until certain court proceedings are finished. That statute has no parallel in the Federal Arbitration Act. In that case, they went to a California court, issued an injunction of an arbitration affecting interstate commerce. Case went up to the U.S. Supreme Court. The argument was The FAA doesn't allow this. What this California court did is violated by the FAA, and under preemption doctrine, they can't do it. The Supreme Court said, no, you're wrong. Arbitration is a creature of contract. Under the FAA, all it says is you have the right to have the agreement enforced as written. You picked California law. So it doesn't matter that California law conflicts with the FAA. We're enforcing this agreement as written. When you pick California law, you essentially put into your contract a provision that is contrary to the FAA, and you have to live with it. So that's all we're really doing here, is saying they need to follow the law as the contract's written, and it just does not authorize an action in California state court. It's very interesting, Florida state court. Interesting, talk about this parade of horribles. Oh my God, how are we going to enforce an agreement? They changed the manual, several. They just write a new manual if that's their problem.
Counsel, do you think, looking back at Deora, do you think the implications of interstate commerce and the application of the FAA have any effect on that?
No, I don't. No, I don't, because the FAA does not allow this kind of action. I mean, you can look at all their cases. There's not a single case of somebody bringing an original Section 4 petition against somebody in state court. They're all cases in which I'm sure this court has heard numerous cases involving arbitration. I'm going to guess 99 times out of 100, somebody files a lawsuit and defensively there's a petition to compel arbitration. This is really an unusual situation here, which gets to an issue that I think Judge Edwards raised. But no, I don't think the fact that it's interstate commerce matters, because the FAA, which is their choice of law, does not authorize this action. They could have brought this case in California along with the other 250 cases. They wanted to enforce it. There was their forum. It was available to them. They chose to come here. And that goes to the other issue that Judge Edwards raised. This is a two-page dispute letter, which is not an exhaustive or complete list of disputes. I think it says the disputes concerned are not limited to. There's a phone conversation in which I'm asked if I would arbitrate, and I say, why would I arbitrate under a clause that's been declared unconscionable by at that point, three courts? That phone call was March 29th, 2022. You know when this petition was filed? March 29th, 2022, the same day. You look at the record, page 393, 1085. They filed this the same day as that conversation. Now, how is a court on this record going to decide? These are very thorny issues of unconscionability. There's at least two issues of unconscionability that we would want to litigate. I don't know how you can decide on this records. One is, what would it cost to arbitrate these claims before a panel of three arbitrators in a unique individual proceeding, because we can't consolidate? How are you going to decide that on this record? Number two, is the discovery permitted by this arbitration clause? 5 interrogatories, 5 document requests, no subparts, no depositions. Does that make it impossible to vindicate the rights we're trying to assert? I don't know how a court could decide that on this record. And so I think as an alternate grounds, this court could rule this simply was not sufficiently ripe for a decision. There's another point I want to make, though.
Counsel, what are the arguments that all they need is 3 things: an agreement, which there's an agreement. I know you dispute that, but in your dispute letter, you rely a lot on the provider manual.
Understood.
So I'm not going to get sidetracked on that right now. But
No,
there's a dispute. There's the informal effort. There's a phone call. How much that was, who knows? They prove that. So then step 3 is you arbitrate. I mean, that's the agreement. Why don't you just have to arbitrate?
Well, I think under the FAA, and Florida law follows the FAA, you need more than simply a casual phone conversation to say there's an unequivocal refusal to arbitrate. Let me be very specific here. This contract also says if there's a dispute over arbitrability, and this is a dispute over arbitrability, how does it get decided? By the arbitrator. This contract actually says you cannot, under any circumstances, take a case to court. So they violated their own contract by bringing an action to compel arbitration when all disputes over arbitrability are supposed to be for the arbitrator. If they really felt that we refused to arbitrate, what they should have done was initiate an arbitration and see if we participated or not. They never initiated an arbitration. Instead, they jumped the gun and came to this court. So if this was a refusal, if this really met the criteria for refusal, and they cite cases, we cite cases, the bottom line is, though, the remedy in their own drafted agreement says go to arbitration. Go to an arbitrator. Go to an arbitrator, say, well, 3 arbitrators. Go to 3 arbitrators and say, is this dispute arbitrable? Here's the letter, is this dispute arbitrable? No. If they had done that back on March 29th or March 30th, I dare say this could have been over by now. But they didn't, and it's not. Along the lines of discussing the policy favoring arbitration, if this court wishes to further the policy favoring arbitration, it will tell them, you're in the wrong forum, your own agreement says you need to arbitrate this dispute. You have no business filing a petition to compel arbitration. I really don't have any additional points to add. If there are any other questions, I'm happy to entertain them.
I don't see a big line of hands
Okay,
up, so.
then I hope I covered all the. I just take a minute to review my notes.
You have 5 minutes. You can
Yeah,
do with
got
what you
it.
want.
I don't have rebuttal. I don't get so rebuttal, huh? That's fine. No, I think that covers it. Thank you.
Thank you.
Thank you.
Counsel?
Thank you, Your Honor. I'm going to try to respond to 3 of the points I heard. The first is that Mr. Kuker said that Section 4 of the FAA has been universally interpreted to require the petition to be filed in a U.S. district court. There's simply no authority for that. No court has ever held that it doesn't apply in state court.
But counsel, would you concede that all the cases that you cited, as far as I could tell, or as far as I could find, the procedural posture is much different than we have here? They were not original filings in state court relying on Section 4. The only reason they were in state court is to confirm the award or something of that nature. It's not what we have here. Is that correct?
That's correct, Your Honor. But under both the Florida Arbitration Code and the FAA, there are 2 ways where you can get a court order compelling arbitration. One is if there's already an action in the court and you defensively file a motion to compel arbitration. Second, under both the FAA and the Florida Arbitration Code, is you can go in with an original petition. All that's required is a refusal to arbitrate. And there are 2 Florida cases that I agree they don't come up in the offensive petition to compel arbitration, but both of them say that Section 4 applies in state court. One of them is the Basalto case from the Florida Supreme Court. It says trial courts are empowered in Florida to compel arbitration under Section 4. And then from the 5th DCA, the Grant v. Rotolante case, which we cite, it's 147 Southern 3rd, 128, says that the FAA, Sections 1 through 16, create a body of federal substantive law that is applicable in both state and federal courts. It provides concurrent jurisdiction to state courts to enforce arbitration agreements. And Mr. Kuker's position seems to be that really Section 4 is never available in state court because you have to file in a U.S. district court. And that's just simply not how courts have interpreted that. The second point I wanted to respond to are about how there are thorny issues of unconscionability here. I think that's premature. As this panel seems to recognize, the first step is there an agreement to arbitrate? Has there been a refusal to arbitrate? And here we didn't even get off the gate because the circuit court found there was no jurisdiction, no power to even consider this petition. So Mr. Kuker put in hundreds of pages of evidence on those allegedly thorny issues, costs, and discovery. We put in hundreds of pages showing why the discovery provision, the costs, there's no problem with that, but the circuit court hasn't even looked at that yet. So I think that issue is simply premature now. The third point I wanted to make is, Mr. Kuker said, you need more than a casual phone call resisting arbitration. I take issue with the fact that this was a casual phone call, friends calling up each other, talking about disputes and arbitration. This was our formal dispute resolution call as provided by our arbitration agreement. It was step 2 of that. And then second, even if for some reason it was a casual call, which it was not, the statute only requires an allegation that the other side has refused to comply with the arbitration contract. And Mr. Kuker is trying to create a new countertextual requirement. Not only do you need a refusal to arbitrate, but it needs to be formal. It needs to be documented. All the statute requires, both FAA and Florida Arbitration Code, is an allegation that there was a refusal to arbitrate. We certainly haven't heard anything here today suggesting there hasn't been a refusal. This appeal might be moot. The whole case might be moot if Mr. Kuker came up here and said, hey, we're fine to arbitrate. We'll arbitrate under the agreement. But every single step of the way, every brief they file, they are continuing to oppose arbitration under our agreement. And for this reason, we ask the court to reverse. At a minimum, there should be a remand so that the circuit court can consider the FAA, which it did not, but we ask for reversal.
All right, thank you very much.
Thank you, Your Honor.
We hope that you all have safe travels and happy holidays. We will be in recess.